Welcome back to Sean Thinking Out Loud. Today we're talking about the Supreme Court's ruling on birthright citizenship. And right away we need to clean up the mess because the national conversation on this issue is already being handled with the precision of a drunk raccoon trying to disassemble a wristwatch. People are saying the Supreme Court ruled on birthright citizenship like there was only one case, one issue, one clean headline, and one easy answer. There wasn't. There were two major parts to this fight. First, there was Trump versus CASA, C-A-S-A, the earlier case dealing with nationwide injunctions. That case was about whether one federal district judge could block a federal policy nationwide for everyone, not just the people in front of that court. That was not the final ruling on whether birthright citizenship is constitutional. Then came Trump versus Barbara. That's the case that actually dealt with the constitutional question. In Trump versus Barbara, the Supreme Court held that children born in the United States to parents who were unlawfully present or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment. That matters. It matters legally, it matters politically, it matters for immigration enforcement, and it matters for how conservatives talk about citizenship, sovereignty, borders, and the Constitution without sounding like they're making it up as they go along. Now, let me say this up front. If your position is that the United States has the right to control its borders, enforce immigration law, deport people who are here illegally, stop visa fraud, shut down birth tourism rackets, and restore order to a broken immigration system, then this ruling doesn't end your argument. Not even close. But if your position is that a president can erase a constitutional citizenship rule by executive order, then the court just told you no. And it should have. That's not weakness, that's constitutional government. You don't save the republic by pretending the executive branch can rewrite the 14th Amendment with a pen and a press release. That's not conservatism. That's just progressive-style executive lawmaking with a different hat on. And I don't care whose name is on the order. Obama didn't get to do it. Biden didn't get to do it. Trump doesn't get to do it. A president is not a one-man constitutional convention. Now, some people on the left are going to celebrate this ruling as if it means immigration enforcement is dead. Wrong. Some people on the right are going to treat this ruling like the Supreme Court surrendered the border. Also wrong. That's the problem with politics now. People want the slogan. Nobody wants the actual legal terrain. And then we wonder why we lose arguments in court. The court did not say illegal immigration is acceptable. The court didn't say the border is meaningless. The court didn't say Congress has no power over immigration. The court did not say birth tourism fraud can't be prosecuted. The court did not say deportations must stop. The court said children born on American soil under American jurisdiction are citizens at birth. That's the ruling. Now, we can fight about whether that's good policy, bad policy, ancient wisdom, modern insanity, constitutional fidelity, or national self-harm. But first, we have to be honest about what happened. I know, horrible burden. Facts. They keep interrupting the performance. This episode has 5 parts. First, we're going to break down what the Supreme Court actually ruled. Second, we're going to go through the history, Dred Scott, the Civil Rights Act of 1866, the 14th Amendment, and Wong Kim Ark. Third, we're going to examine the conservative argument against modern birthright citizenship, especially the phrase subject to the jurisdiction. Fourth, we're going to talk about immigration enforcement after this ruling. What still works, what doesn't, and where the government still has power. Fifth, we're going to talk about citizenship itself, because this argument is bigger than one executive order. It's about whether citizenship is a constitutional status, a political weapon, a border control incentive, or a national inheritance. And if we're going to talk about American citizenship, we should do it like adults, or at least people who need more than a headline before embarrassing themselves in public. This episode is brought to you by Dismantling the Republic, the role of progressive elites in America's descent into tribalism. If you want a deeper look at citizenship decline, immigration politics, constitutional erosion, bureaucratic power, and the way America keeps replacing citizens with managed political categories, this book belongs on your shelf. Not because it tells you what to think, because it forces you to look at what's been happening while the professional class keeps smiling and tell you everything is normal. It's available through Sean Armstrong and Super Gringo Books. Now back to the show.
Every time I tried to stand, they pushed me down. Now I've had enough, can't take it all around. It's time to be strong, time to be clear. No more being used, it's time to repair. No more Mr. Nice Guy, I'm through. Time to stand up, let the world see. No more being weak, it's time to break. I'm done with the pain, I'll take my place.
Let's start with the actual decision. The case is Trump versus Barbara. The question was whether the Constitution guarantees citizenship to children born in the United States when their parents are unlawfully present or temporarily present in the country. President Trump's executive order said those children were not subject to the jurisdiction of the United States and therefore didn't qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act. The court rejected that argument. The holding was clear. Children born in the United States to parents unlawfully or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment's Citizenship Clause. That's the battlefield. Not vibes, not campaign slogans, not "my side feels betrayed." The actual question was constitutional text. The 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. There are two parts, born or naturalized in the United States, and subject to the jurisdiction of the United States. The Trump order tried to make parental immigration status the controlling issue. The court said no. The court treated jurisdiction as the power of the United States to govern the person born here. If you're born in the United States and you're not in one of the historically recognized exemptions, such as the child of a foreign diplomat or enemy occupying force, then you're under American jurisdiction. You're subject to American law. You can be protected by American law. You can also be punished under American law. That's jurisdiction. This is where people start trying to play word games. They say, well, illegal aliens aren't subject to our jurisdiction. Really? Then how do we arrest them? How do we detain them? How do we deport them? How do we prosecute them for crimes committed inside the United States? You can't say someone is outside U.S. jurisdiction when you want to deny citizenship to their child, then say they're inside U.S. jurisdiction when you want to enforce the law against them. That's not constitutional interpretation. That's cafeteria logic. You don't get to build a legal theory out of whatever is useful at the moment and then act shocked when judges notice. Now, this doesn't mean the dissent had no argument. We'll get there. The dissent focused heavily on allegiance, domicile, foreign power, historical understandings, and the idea that temporary visitors or illegal entrants shouldn't be treated as the same as settled residents. That's a serious argument. But the majority didn't buy it. The majority saw the citizenship rule as broad, territorial, and rooted in post-Civil War constitutional settlement. The child is born here. The child is under the authority of the United States. The child is a citizen. That's the rule. Now, there's another point here that matters. The court didn't create birthright citizenship in this case. It reaffirmed it. That difference matters. The 14th Amendment was ratified in 1868. Wong Kim Ark was decided in 1898. For over a century, the American legal system has operated under a broad understanding of birthright citizenship. So when people say the court just invented citizenship for the children of illegal immigrants, no, it didn't. It applied a constitutional rule to a modern fact pattern. You may not like the application. You may think modern illegal immigration creates problems the Reconstruction generation didn't fully imagine. That's a fair political argument, but it doesn't mean the court invented the rule yesterday. Now let's separate this from the Trump versus CASA. That earlier case was about universal injunctions. In plain English, it was about whether one district judge could block a federal policy everywhere, for everyone, before the full merits were resolved. The Supreme Court limited that kind of nationwide judicial relief. That ruling helped the executive branch in the short term because it made it harder for a lower court judges to freeze national policies across the entire country with one order. But CASA didn't decide whether Trump's birthright citizenship order was constitutional. It specifically dealt with remedies. That distinction matters, because after CASA, a lot of people acted like Trump had won the birthright citizenship fight. No. He had won the procedural fight. That's like saying you won the war because you got better parking at headquarters. The real fight still had to happen. And in Barbara, on the merits, the administration lost. So what happened? The executive branch tried to narrow birthright citizenship through executive order. The court said the Constitution doesn't allow that. The court reaffirmed that children born here to unlawfully present or temporarily present parents are citizens at birth. And now the political argument moves somewhere else. To Congress, to the amendment process, to immigration enforcement, to visa rules, to border control, to fraud prosecution, to deportation priorities, to state and federal cooperation, to asylum reform, to ending incentives that encourage people to violate immigration law in the first place. The Constitution answers one question. It doesn't solve every policy problem, and this is where both sides usually start lying. The left wants to pretend birthright citizenship means there's no immigration crisis. The right sometimes wants to pretend the immigration crisis means the Constitution should bend until it says that we need what we need this week. Both are wrong. The rule of law doesn't mean you always get the policy outcome you want. It means there's a process, a structure, and a chain of authority. That's supposed to be the conservative position. Don't abandon it because one case annoyed you. To understand the ruling, you have to go back before Trump, before Biden, before Obama, before the modern immigration system, before cable news turned every legal issue into professional screaming. You have to go back to the Civil War and Reconstruction. The Birthright Citizenship Clause did not appear out of nowhere. It was a direct response to one of the worst Supreme Court decisions in American history, Dred Scott versus Sanford. In Dred Scott, the Supreme Court held that black Americans, whether enslaved or free, couldn't be citizens of the United States. That decision wasn't just legally wrong, it was morally diseased. It tried to write an entire class of people out of the political community. The Civil War shattered that system. The Reconstruction Amendments were designed to rebuild the legal foundation of the country. The 13th Amendment abolished slavery. The 14th Amendment established citizenship, due process, equal protection, and limits on state abuse. The 15th Amendment protected voting rights against racial discrimination. The Citizenship Clause is the opening move of the 14th Amendment. That's not an accident. Before you can talk about privileges or immunities due to process, equal protection, or voting rights, you have to answer a basic question. Who belongs to the country? Who's a citizen? Who can't be reduced to a political object by whatever faction holds power? The 14th Amendment answered that question by constitutionalizing citizenship. It didn't leave citizenship entirely at the mercy of Congress. It didn't leave it to states. It didn't let the executive branch decide who counts as an American this year. It put citizenship into the Constitution. Before the 14th Amendment, Congress passed the Civil Rights Act of 1866. That act declared that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, were citizens. That law was aimed at destroying the legal residue of slavery in Dred Scott, but Congress understood something important. A statute can be repealed. A statute can be undermined. A statute can be ignored by hostile courts. So the Citizenship Clause moved the principle into the Constitution itself. That's why this issue is so much bigger than immigration policy. The clause wasn't written as a border management tool. It was written as a constitutional guarantee. That doesn't mean immigration consequences are irrelevant. They're very relevant. But the clause was born out of Reconstruction, not out of a modern argument over asylum abuse, illegal entry, visa overstays, or birth tourism. The historical origin matters, because when people say the 14th Amendment was only about freed slaves, they're partly right about the central purpose and wrong about the legal scope. Yes, the immediate historical problem was the status of freed slaves and their descendants. But the text says all persons, not all formally enslaved persons, not all persons whose parents are citizens, not all persons whose parents are legally admitted permanent residents, all persons born or naturalized in the United States and subject to the jurisdiction thereof. When constitutional text is broad, courts usually treat it as broad. Again, shocking development, words matter. Now enter United States versus Wong Kim Ark. Wong Kim Ark was born in San Francisco in 1873. His parents were Chinese subjects who lived in the United States but couldn't become naturalized citizens because of the racist immigration and naturalization laws of that period. Wong traveled abroad and was denied re-entry on the claim that he was not a citizen. The question reached the Supreme Court. In 1898, the court held that Wong Kim Ark was a citizen by birth under the 14th Amendment. That case became the central precedent in Americans' birthright citizenship law. The government tried to argue that because Wong's parents were subjects of China, he was not fully subject to U.S. jurisdiction. The court rejected that. The key idea was that birth on U.S. soil under U.S. jurisdiction conferred citizenship except for narrow historical exceptions. Children of foreign diplomats, children born to enemy forces occupying U.S. territory, and historically, Native Americans born into tribal allegiance were treated differently until later citizenship law changed that status. The broad rule remained. If you were born here and subject to U.S. jurisdiction, you're a citizen. Now, critics of modern birthright citizenship argue that Wong Kim Ark doesn't settle the question for children of illegal immigrants or temporary visitors because Wong's parents were domiciled in the United States. That's not a stupid point. Wong's parents weren't illegal entrants. They were living in the United States. So the critics argue that the case should be read narrowly. But the majority in Trump versus Barbara didn't accept that narrow reading. The majority treated Wong Kim Ark as confirming the broader territorial citizenship rule. The court reasoned that children born in the United States to unlawfully or temporarily present parents are still under American jurisdiction. They're not diplomats. They're not the children of an invading army. They're not born in some legal vacuum. They're born inside the United States. They're governed by U.S. law. Therefore, they're subject to U.S. jurisdiction. That's the chain of logic. You can disagree with it, but you should be able to state it honestly before attacking it. That alone should raise the quality of public argument by about 400%, which tells you how low the starting point is. Now let's talk about why this history creates tension for conservatives. Conservatives generally claim to care about constitutional text, original meaning, historical practice, separation of powers, and limits on executive power. That's the brand. That's supposed to be the deal. So when a Republican president tries to rewrite citizenship by executive order, conservatives have a problem. Because even if you support strong immigration enforcement, even if you think birthright citizenship creates perverse incentives, even if you think the current rule is abused, you still have to ask, does the president have the power to change this alone? The answer is no. Not if the citizenship clause means what the court says it means. And that's where discipline matters. A constitutional conservative doesn't say, I support executive orders when my side writes them. That's how the other side thinks. That's how you get student loan cancellation by executive order. That's how you get border law ignored by executive discretion. That's how you get agencies inventing rules that Congress never passed. You can't spend years complaining about executive overreach and then cheer when your guy tries the same disease with better marketing. If birthright citizenship needs to change, then the honest path is constitutional amendment. That's hard. It should be hard. Changing the terms of national citizenship shouldn't be as easy as changing a campaign slogan. The fact that something is politically difficult doesn't mean you get to cheat the structure. That's the point of constitutional government. The Constitution is not there to make your preferred policy easy. It's there to keep power constrained, even when your side is in power. Especially then. This episode is brought to you by the unmaking of the American citizen, neoliberalism, identity politics, and the conservative renewal. If today's episode is about anything, it's about citizenship. What it means, how it gets weakened, how elites turn citizens into managed categories, how government stops treating people like members of a republic and starts treating them like demographic inventory. That's the argument at the heart of the unmaking of the American citizen. If you care about citizenship as more than paperwork, read the book. Now, back to the show. Now, let's steel man the argument against modern birthright citizenship. Because if you can't explain the other side fairly, you're not arguing, you're just making noise with grammar. The conservative argument against broad birthright citizenship usually goes like this. The citizenship clause says a person must be born in the United States and subject to the jurisdiction thereof. The second phrase must mean something. It can't be meaningless decoration. Critics argue that subject to the jurisdiction meant more than being physically present and subject to some American laws. They say it means complete political jurisdiction. They say it involved allegiance. They say it excluded people who owed allegiance to another sovereign. They say the children of illegal immigrants or temporary visitors shouldn't automatically become citizens because their parents are not part of the American political community. That's the argument. And that's not crazy. It's a serious textual and historical argument. The dissent in Trump versus Barbara leaned into this point. Justice Thomas, for example, focused on the idea that the original meaning of the phrase required a fuller form of jurisdiction tied to allegiance and domicile. The dissent cited 19th century material suggesting that some legal writers and officials believed that children of temporary foreign visitors were not citizens by birth. That matters. You can't just wave it away because it makes the modern consensus uncomfortable. There was historical disagreement. There were legal sources that didn't read the clause as broadly as modern doctrine reads it. That's true. But here's the problem. The majority looked at the broader structure, the text, the historical purpose, and precedent, and it concluded that the child born here is subject to American jurisdiction unless a recognized sovereign exception applies. The majority didn't treat illegal presence or temporary presence as the same kind of exemption as diplomatic immunity or enemy occupation. And that distinction is important. A foreign diplomat is not fully under U.S. jurisdiction in an ordinary way. The child of an invading army is born under hostile occupation, not normal civil authority. Those exceptions involve sovereignty conflicts. But an illegal immigrant inside the United States is still subject to U.S. law. A tourist is subject to U.S. law. A student visa holder is subject to U.S. law. A temporary worker is subject to U.S. law. If they commit crimes, they can be arrested. If they violate immigration law, they can be removed. If they sue, they can appear in court. If they are victimized, they can receive legal protection. That looks like jurisdiction. Again, inconvenient little thing called legal consistency. The anti-birthright argument becomes strongest when it shifts away from pure jurisdiction and toward policy, because there are legitimate policy problems here. Birthright citizenship can create incentives. Birth tourism is real. Visa fraud is real. People do abuse systems. Illegal immigration can produce mixed status households where the child is a citizen and the parents are removable. That creates legal, political, and humanitarian complications. It also creates enforcement friction. It can make deportation politically harder. It can make families more difficult to remove. It can create future chain migration arguments. It can create the perception that crossing the border illegally can still plant a permanent legal stake inside the country. Those concerns are real. Pretending they're not real is stupid. But real policy concerns don't automatically rewrite constitutional text. That's the hard part. A policy problem might justify enforcement changes. It might justify visa reform. It might justify asylum reform. It might justify more aggressive fraud prosecution. It might justify detention reform. It might justify congressional action. It might justify a constitutional amendment campaign, but it doesn't automatically justify executive reinterpretation of citizenship. That's the line. Now let's address one of the most common talking points. People say no other country does this. That's false. Several countries in the Americas have birthright citizenship in some form. But even if it were true, it wouldn't decide the American constitutional question. The United States has its own constitutional history. You don't interpret the 14th Amendment by checking what France or Germany does. Different countries define citizenship differently. Some use ancestry, some use birthplace, some use mixed systems, some have strong restrictions. Some change the rules because immigration patterns changed. That's all relevant to policy debate. It's not controlling constitutional authority. The United States built birthright citizenship into the 14th Amendment after a civil war over slavery, citizenship, and national membership. That's not a minor detail. That's the whole spine of the issue. Now let's talk about the phrase anchor baby, because apparently no political debate is complete until someone reaches for the ugliest possible shorthand. The term is emotionally loaded, but the underlying concern is this. A child's citizenship can eventually become part of an immigration pathway for family members. But here's where people need to be precise. A U.S. citizen child can't immediately sponsor parents for lawful permanent residence while still a child. Under current immigration law, a U.S. citizen generally must be at least 21 years old to petition for a parent. So the idea that a baby instantly legalizes the whole family is wrong. It doesn't work like that. However, the child's citizenship can still affect the family's long-term position. It can affect prosecutorial discretion. It can affect political sympathy. It can affect removal decisions. It can affect future sponsorship. It can affect public benefits indirectly through household structure. So both simplistic arguments are wrong. The left says there's no incentive or enforcement impact. False. The right sometimes says citizenship instantly legalizes the parents. Also false. Reality sits where it usually sits, in the details nobody wants to read. Now, there's also the matter of temporary visitors. This is where the dissent's argument was more intuitive force for many people. A tourist flies into the United States, gives birth, and leaves. Should that child be a citizen? The modern constitutional answer after Trump versus Barbara is yes, unless the parents fall into a recognized exception like diplomatic status. That bothers a lot of people, and I understand why. A tourist is not immigrating. A tourist is not joining the national community. A tourist is not building a life here. So people ask, why should the child receive citizenship? That's a fair policy question. But the court's answer is constitutional, not emotional. The child was born in the United States. The child was subject to U.S. jurisdiction. The Constitution grants citizenship. If you want to change that, don't pretend the president can fix it alone. Go amend the Constitution, or tighten visa issuance, or crack down on fraud, or deny visas to people believed to be traveling primarily to give birth, or prosecute birth tourism operations that lie on visa applications, launder money, or organize fraud. There are tools. They're just less emotionally satisfying than pretending one executive order can bulldoze 150 years of constitutional law. This is where conservatives need to decide what they actually are. Are we constitutionalists, or are we just progressives with different enemies? Because the progressive model is easy. Find a desired outcome, declare an emergency, stretch executive power, ignore Congress, attack the courts when they resist, pretend the Constitution is a suggestion box. Conservatives are supposed to reject that, so reject it, even when the issue is immigration, even when the ruling is frustrating, even when the policy consequences are ugly, because the alternative is worse. Once you accept executive prosecutorial revision for your preferred issue, you have no principled argument left when the other side does it on guns, speech, religion, schools, property, energy, or elections. You gave away the principle, and once you give away the principle, don't complain when it gets used against you. Now let's get practical. What does this ruling do to immigration enforcement? The answer is less than the left wants and more than some on the right want to admit. The ruling blocks one specific path. The government can't deny citizenship to covered children born in the United States born on the unlawful or temporary status of the parents. That's the main impact. But immigration enforcement remains alive. The government can still deport parents who are unlawfully present, subject to statutory or constitutional procedures. The government can still detain people. The government can still prosecute immigration-related crimes. The government can still remove people after lawful process. The government can still police visa fraud. The government can still investigate birth tourism schemes. The government can still tighten visa screening. The government can still change asylum procedures within constitutional and statutory limits. The government can still build border infrastructure. The government can still require e-verify if Congress acts. The government can still penalize employers who knowingly hire unauthorized workers. The government can still cooperate with state and local agencies where law allows. The government can still prioritize removals. The government can still end parole abuse. The government can still enforce overstays. The government can still secure the border. So no, this ruling doesn't mean immigration enforcement is dead. It means birthright citizenship can't be eliminated by executive order. Those are different things. A functioning adult should be able to hold both thoughts at once. Ambitious, I know. Now let's talk about mixed status families. This ruling preserves the citizenship of children born in the United States even when parents are unlawfully present. That means immigration enforcement will continue to run into households where some members are citizens and others are not. That's already true. This ruling keeps that reality in place. That creates hard cases. A parent can be removable while the child is a citizen. A child has rights. A removable parent has process rights, but not the right to remain simply because the child is a citizen. That distinction matters. The Constitution doesn't say a parent gets lawful status because the child is a citizen, but politics doesn't operate purely on legal categories. Deporting the parent of a citizen child creates public controversy. It creates media stories. It creates hardship claims. It creates pressure on agencies. It creates pressure on judges. It creates pressure on Congress. It doesn't make enforcement illegal, but it does make enforcement more complicated. So the ruling preserves an enforcement problem that already existed. It doesn't create it from scratch. This is where serious immigration policy has to stop chasing symbolic victories and start dealing with systems. If you want less illegal immigration, enforce at the border. If you want fewer visa overstays, track exits and enforce consequences. If you want to reduce employment magnets, hit employers who knowingly hire illegal labor. If you want to reduce birth tourism, tighten visa screening and prosecute fraud networks. If you want fewer bogus asylum claims, reform asylum standards and speed adjudication while preserving legitimate claims. If you want fewer incentives for illegal entry, stop using parole as a shadow immigration system. If you want fewer long-term illegal residents, remove people faster after final orders. If you want real reform, Congress has to do its job. Yes, Congress! That fossil exhibit with microphones, it exists for a reason. Now, one of the most important enforcement impacts after this ruling is that the government will likely shift attention towards birth tourism. Birth tourism is when foreign nationals travel to the United States for the purpose of giving birth so the child receives U.S. citizenship. Now, simply giving birth in the United States is not fraud by itself, but lying to obtain a visa can be fraud. Concealing the purpose of travel can be fraud. Organized schemes that coach applicants, hide pregnancies, falsify documents, launder money, or misrepresent intent can become criminal cases. That's where enforcement can go. And frankly, that's where enforcement should go, because you don't need to erase constitutional citizenship to punish fraud. You punish fraud by proving fraud. There's a concept. Use the law that applies to the conduct, not the law you wish existed because you're angry. The government can also adjust consular and visa policy. If officials believe someone is seeking a visa primarily for birth tourism, they can scrutinize the application. They can deny visas where the law permits. They can require stronger evidence of legitimate travel. They can target agencies that advertise birth tourism packages. They can coordinate across state departments, DHS and DOJ. That's lawful enforcement work. Slow, boring, document-heavy, effective when done properly, which is obviously why politicians prefer yelling about executive orders. Now let's address the border. Birthright citizenship is not the primary driver of illegal immigration. It's one factor in the broader incentive structure. People cross illegally for work, family, safety, cartel pressure, economic opportunity, asylum claims, and because they believe the American system still will eventually let them stay. Birthright citizenship may be a part of that calculation for some people. But if you think ending birthright citizenship alone would secure the border, you're kidding yourself. The border crisis exists because enforcement has been inconsistent. Asylum has been abused, court backlogs are massive, employers benefit from illegal labor, political leaders refuse to make hard choices, and both parties have used immigration as a campaign weapon while avoiding durable reform. Birthright citizenship is one piece, not the whole machine. The ruling also affects bureaucratic operations. If Trump's executive order had survived, agencies would have faced a nightmare. Hospitals, state vital records offices, passport agencies, Social Security Administration, immigration agencies, schools, benefits offices, everywhere citizenship status matters, someone would need to determine parental status at the time of birth. That means documents, investigations, disputes, appeals, lawsuits, delays, errors. Imagine a child born in Texas, mother unlawfully present, father unknown, or father lawful permanent resident, or father citizen but not on the paperwork, or a mother on a temporary visa, or a mother with pending asylum, or father with DACA, or one parent with parole, or a status change pending. Now multiply that by hundreds of thousands of births. That administrative mess would be enormous. And when government systems get overwhelmed, innocent people get caught in the gears. That doesn't mean birthright citizenship must remain forever. It means changing it is not a clean switch. It's a major legal and administrative operation. Pretending otherwise is campaign nonsense. There's another enforcement issue, statelessness. If the United States denied citizenship to children born here, some of those children might receive citizenship from their parents' countries. Some might not. Different countries have different nationality laws. Some grant citizenship by blood automatically. Some restrict it. Some have documentation requirements. Some discriminate by sex of the parent. Some require registration. Some require legal recognition by the father. Some countries are bureaucratic disasters. So ending birthright citizenship could create a class of children born in the United States who are not clearly citizens anywhere. That's not a small issue. A serious country shouldn't create legal ghosts inside its own borders because it wanted a quick political win. If you want to change birthright citizenship, you need a plan for nationality, documentation, removal, education benefits, and legal status. You need more than a slogan. Again, tyrannical requirement thinking. Now, the enforcement takeaway is this. The Supreme Court ruling narrows the government's option on citizenship. It doesn't narrow the government's core immigration powers. It doesn't stop deportation. It doesn't stop border security. It doesn't stop visa enforcement. It doesn't stop fraud prosecution. It doesn't stop Congress from legislating within constitutional limits. It doesn't stop a constitutional amendment campaign. It doesn't tell the executive branch you can't redefine American citizenship. It does tell the executive branch you can't redefine American citizenship by order. That's the line. And if conservatives are serious about law and order, they should respect the line while fighting hard everywhere else that law applies or law allows. This episode is brought to you by From Jobs to Justice, The Trump Era Examined, and Messiah. 2 books, 2 administrations, 2 very different political eras. Same basic question. What did they actually do? Not what their fans pretended, not what their enemies screamed. What policies did they pursue? What consequences followed? And what did those years reveal about American government? From Jobs to Justice examines the Trump administration across trade, energy, defense, foreign policy, and veterans affairs. Messiah takes on the Obama administration across the economy, foreign policy, immigration, and health care. If you want political commentary with a spine, read both. Now back to the ruling. Now we need to step back, because the fight over birthright citizenship is really a fight over what citizenship means. Is citizenship just a legal status? Is it a constitutional guarantee? Is it a national inheritance? Is it a civic bond? Is it a political identity? Is it a shield against government abuse? Is it a tool of immigration policy? The answer is yes. It's all of those things. And that's why this issue is so explosive. Citizenship isn't just a passport. It's membership in the political community. It's the status that gives you the right to remain the right to return, the right to vote when you reach age, the right to claim protection, the right to belong. That's why it shouldn't be cheapened. But it's also why it shouldn't casually be denied. Citizenship is too important to treat like a door prize. It's also too important to treat like an executive policy preference. Both sides need to absorb that. The left often treats citizenship as if it's morally owed to anyone who arrives, stays, suffers, works, or wants a better life. That's not how a nation works. A country has borders, a country has laws, a country has the right to decide who enters, who stays, who naturalizes, and who must leave. Compassion doesn't erase sovereignty. Need doesn't erase law. Suffering doesn't automatically create a right to enter another country. That sounds harsh, but only to people who've confused government with therapy. But the right has its own problem. Some conservatives talk about citizenship like it should be adjustable whenever illegal immigration gets bad enough. That's dangerous. Citizenship is the foundation of political rights. Once you start treating citizenship as something the executive can narrow through reinterpretation, you're playing with constitutional fire. Today it's children of illegal immigrants. Tomorrow someone else will decide another group isn't really part of the country. Don't hand future governments tools you wouldn't trust with your enemies to use. That's one of the simplest rules in politics. Almost nobody follows it. Because apparently touching the hot stove is a bipartisan tradition. Now let's talk about sovereignty. People who support ending or narrowing birthright citizenship often say that current rule weakens sovereignty. They argue that a sovereign nation must control membership. That's true in principle. A nation must control its membership. But under the American system, sovereignty is exercised through the Constitution. The Constitution isn't anti-sovereignty. It's the legal form of American sovereignty. So if the Constitution defines citizenship broadly, that's not a violation of sovereignty. That's sovereignty speaking through constitutional law. If the people want to change the definition, the people can amend the Constitution. That's also sovereignty. But a president unilaterally narrowing constitutional citizenship isn't sovereignty. It's executive overreach. That distinction matters. Sovereignty doesn't mean whatever the president wants. Sovereignty belongs to the people through constitutional structure. That structure includes Congress, it includes courts, it includes amendments, it includes elections, it includes limits. Without limits, sovereignty becomes a slogan for power. Now let's talk strategy. Where should conservatives go after this ruling? First, stop pretending the ruling killed immigration enforcement. It didn't. Second, stop making sloppy constitutional claims. If you want to argue for a constitutional amendment, say that. If you want to argue for statutory reform, say that. If you want to argue for visa enforcement, say that. If you want to argue for deportation expansion, say that. If you want to argue for employer sanctions, say that. Don't hide a policy goal inside a weak legal theory and then act surprised when courts reject it. Third, focus on enforceable tools. Border control, detention capacity, immigration court speed, asylum reform, visa overstay tracking, birth tourism fraud, worksite enforcement, state-federal cooperation, removal of final order cases, consular screening, and abuse of people, correction, and abuse of parole, and bureaucratic sabotage. Those are real. Those matter. Those can be defended without trying to bend the citizenship clause into a campaign slogan. Fourth, conservatives should reclaim the language of citizenship. Citizenship isn't just paperwork. Citizenship carries duties. Assimilation matters. Civic knowledge matters. Language matters. Loyalty matters. The rule of law matters. The left has spent years reducing citizenship into benefits, identity categories, and grievance management. That should be challenged, but you don't challenge it by weakening constitutional citizenship. You challenge it by restoring civic seriousness. You teach people what the country is. You enforce the law. You demand assimilation. You end illegal labor markets. You punish fraud. You stop pretending every border violation is a human rights sacrament. And you stop pretending every immigrant is a future voting bloc or a future cheap worker. People aren't inventory. Citizenship isn't demographic strategy. A republic needs citizens, not clients. Fifth, the right needs to separate two arguments that keep getting mashed together. Argument 1. Children born in the United States are citizens under the 14th Amendment. Argument 2. Current immigration policy creates incentives that damage the country. Both can be true. You can defend the constitutional rule and still demand hard immigration enforcement. You can accept the court's ruling and still say the border must be secured. You could say a child born here is a citizen and still say the unlawfully present parent may be deported. You can reject executive overreach and still support aggressive enforcement. This isn't complicated unless you've been trained by social media to think every issue requires tribal brain damage. Now let me say something that will annoy both sides. The Constitution doesn't care about your emotional convenience. It doesn't care if enforcing the border is politically hard. It doesn't care if changing citizenship rules is legally hard. It doesn't care if a ruling helps your enemy talking points. It doesn't care if your preferred policy would be easier under a different constitutional structure. The whole point of a constitution is to bind power before power gets excited. That means your side gets bound too. That's not betrayal, that's the system. If we abandon that whenever immigration gets hard, then we're not defending the republic, we're just managing panic. Now, does this ruling create political problems? Yes. It gives the left a victory. It preserves an incentive structure that many Americans reasonably dislike. It makes it harder to attack one part of illegal immigration through citizenship rules. It forces the right back into slower, harder, less dramatic policy work. Good. Do the work. Secure the border. Fix asylum. Track visas. Remove people with final orders. Stop illegal employment. Serious reform. And if you write citizenship, start the amendment argument honestly. Make the case to the American people. Don't pretend a president can do it alone. The strongest conservative response to this ruling isn't rage. It's discipline. Respect the constitutional holding. Reject the left's attempt to turn it into open borders propaganda. Enforce every lawful immigration tool available. Demand Congress act. And tell the American people the truth. Birthright citizenship is constitutionally protected. Illegal immigration is still illegal. Citizenship matters. Borders matter. Law matters. All of those things can be true at the same time. Before we close, a final plug for the Consent of the Governed, the fundamental principles in the Federalist Papers and its relevance today. If this episode makes anything clear, it's that constitutional government requires more than slogans. It requires structure, consent, limits, separation of powers, a people who understand that government isn't supposed to become a shortcut machine for whatever faction is angry this week. Consent of the Governed gets into those principles through the lens of the Federalist Papers and American constitutional thought. Read it if you want to understand why process isn't weakness. It's the armor. So where does that leave us? The Supreme Court has reaffirmed birthright citizenship. Children born in the United States to parents unlawfully or temporarily present are citizens at birth under the 14th Amendment. That's the law after Trump versus Barbara. The older Trump versus CASA case limited nationwide injunctions, but it didn't decide the citizenship question. Barbara did. That distinction matters. Historically, birthright citizenship grew out of the wreckage of slavery and Dred Scott. It was written into the 14th Amendment to make citizenship secure, not dependent on state governments, not dependent on hostile political factions, not dependent on executive preference. Wong Kim Ark later confirmed that this principle applied broadly to children born on American soil under American jurisdiction. Trump versus Barbara reaffirmed that rule in the modern immigration context. Now, does that solve the immigration crisis? No. Does it excuse illegal immigration? No. Does it stop deportations? No. Does it stop visa enforcement? No. Does it prevent prosecution of birth tourism fraud? No. Does it mean America has no right to control its borders? No. What it means is simple. The government can't erase birthright citizenship by executive order. If that bothers you, your problem isn't with one court ruling. Your problem is with the constitutional structure itself. And if you want to change that structure, there's a process. Use it. The right shouldn't walk away from immigration enforcement because of this ruling. The right should get more serious, more precise, more disciplined. Stop looking for magic executive order solutions. Stop letting the left define enforcement as cruelty. Stop pretending citizenship and borders are enemies. They're not. A real country needs both. A border defines the territory. Citizenship defines the people. Law defines the process. And discipline keeps all three from turning into political sewage. The final point is this. A republic can't survive if citizenship means everything and nothing at the same time. It can't survive if the left turns citizenship into managed dependency. It can't survive if judges invent law. It can't survive if presidents rewrite law. It can't survive if Congress refuses to do law. And it definitely can't survive if the public gets all its constitutional education from memes written by people who think jurisdiction is a new energy drink. Birthright citizenship is protected. Immigration law still exists. The border still matters. The Constitution still binds the president. And the American people still have the power to demand real enforcement from the branches that actually have the authority to act. That's the fight now. Not panic, not slogans, not fake legal shortcuts. The fight is law, enforcement, citizenship, and national survival handled like adults, for once. This has been Sean thinking out loud. Stay sharp, read the law, know the history, and never let anyone sell you constitutional illiteracy wrapped in a flag.